call the Committee on Oversight and Reform to order. A quorum is present, and without objection, the Chair may call a recess at any time. Eight years ago, Chairman Issa started a tradition that I liked. He started off by having a member say a prayer at this organizational meeting. I've asked the distinguished member from the great state of Michigan, Ms. Lawrence, to lead us in prayer. I yield to the gentle lady.
We take an oath of office that we will faithfully discharge the duties of this office, so help me God. We support our families with money which is engraved in God we trust. We sing a patriotic song, God bless America. It is fitting and appropriate that we pray. God, Heavenly Father, our supreme being, today we begin our work. We are a small group of men and women, a group of diverse people. We come from different places. We have different beliefs, and we have different political affiliations, but we share so many things. Love of family, love of country, and we share the vote and the trust of the people to provide oversight for our government. We pray today for wisdom, that we never stop seeking the facts. We pray for strength, not power, but strength to speak the truth and to stand when others sit. We pray for compassion so that our ears will continue to hear the cry of the people, that our eyes will see the reality of right and wrong. I pray today we'll never lose the respect of each other, but rather in humility value each other. I pray today that we commit ourselves to the ultimate fight, and that is for one nation under God with liberty and justice for all. Amen. I
thank the gentle lady. Good morning, everyone, and welcome to our returning members and all of our new members. This is the organizational meeting of the Committee on Oversight and Reform for the 116th Congress. We'll have several votes today, so I encourage all members to attend the full meeting, and I emphasize that, the full meeting. Then, after our organizational meeting at 11 a.m., we will have our first hearing on prescription drugs. For this organizational meeting, I would like to proceed as follows. First, Ranking Member Jordan and I will introduce our new members on each side. Next, I will introduce the Vice Chair of the committee. Third, we will introduce our subcommittee chairs and ranking members. And finally, we will officially adopt the committee rules, the subcommittee chairs and the ranking members, and the member subcommittee assignments. So let us proceed. First, I would like to introduce the new majority members of the committee. It is a talented and energetic group that will be instrumental in helping us accomplish our work this Congress. I would like to welcome two returning members who are new to our committee, Representative Wasserman Schultz and Representative Kahana. Give them a hand, please. I also welcome 5 Democratic members of the freshman class who have been appointed to the committee. Holly Ruda of California, Katie Hill of California, Alexandria Ocasio-Cortez of New York, Ayanna Presley of Massachusetts, and Rashida Tlaib of Michigan. They are a dynamic group, and I look forward to working with them. Give them a hand, please. I also introduce our new Vice Chair of the committee. Before I do that, I want to sincerely thank Representative Jerry Connolly for serving in the position of Vice Ranking Member so ably during the last Congress. I've said it before, but I'll say it again. Having laid in Johns Hopkins Hospital for 6 months, thinking about my life and my death, I had the privilege of having Jerry Connolly over and over again stand for me, with me, by me, and substitute for me. And Jerry, I want to make it clear that I shall forever be grateful for your support. Give him a hand, please. For this Congress, the Vice Chair of the Oversight Committee will be Representative Katie Hill of California. She is a dynamic new freshman who previously served as the Executive Director of People Assisting the Homeless, the largest homeless services organization in California, where she helped thousands of chronically homeless individuals and veterans and families. She will be helping us with all aspects of the committee's operations and playing a lead and pivotal role in helping to craft the committee's oversight agenda for the 116th Congress. And I want to thank Representative Hill for taking on those responsibilities. Now, I would like to yield to our distinguished ranking member, Representative Jordan from the great state of Ohio, to introduce our new Republican members.
Thank you, Mr. Chairman, and let me first of all congratulate you. I have the highest respect for you. I appreciate your toughness, your tenacity. Most importantly, I appreciate your willingness to fight for your constituents and the policies that you believe in. You've done that time and time again, and that is something I respect from you and from every member who does that. I also appreciate the fine prayer that Ms. Lawrence offered for the start of this important committee at this important time in our nation's history. I, too, want to welcome all the members to the committee, both sides, new, and those who have been in Congress who are new to just this committee. On our side, we have 8. First, Bob Gibbs of Ohio, another Buckeye, new to this committee but not to Congress. He's a farmer, a businessman, and a veteran of the Ohio House and Senate. We're glad Bob is with us. Mr. Clay Higgins of Louisiana is another new member to this committee but not to Congress. We welcome Clay's experience as a veteran and a law enforcement officer and are glad that he is part of our team. Ralph Norman of South Carolina brings experience as a businessman, local legislator, as well as a year and a half in Congress, and he too has been here but new to the Oversight Committee. Mr. Chip Roy of Texas, former federal prosecutor, senior congressional staff member. This experience will, I think, serve us all well. Also, his work in the private sector will be a benefit to this committee. Carol Miller represents the 3rd District of West Virginia. She also brings a wealth of experience from the West Virginia legislature, and we are glad that Carol is part of our team. Mr. Mark Green of Tennessee, West Point graduate, Army infantry officer, doctor, business executive, and a former member of the Tennessee legislature. And Kelly Armstrong of North Dakota brings real-world experience as a lawyer, businessman, in addition to his experience as a local legislator. And finally, Mr. Greg Stubbe of Florida. Greg is an Army veteran, a lawyer, and was a member of the Florida House and Senate. Maybe we should continue the tradition and welcome all these people and give them our approval and thanks as new members of the committee. Mr. Chairman, I yield back.
Thank you very much. Now we would like to introduce our 5 subcommittee chairs and 5 ranking members. First, on the majority side, our 5 chairs will be Representative Stephen Lynch, National Security, Representative Jerry Connolly, Government Operations, Representative Raja Krishnamurthy, Economic and Consumer Policy, Representative Jamie Raskin, Civil Rights and Civil Liberties, Representative Harley Ruda, Subcommittee on the Environment. I now yield to the distinguished gentleman, Mr. Jordan, our ranking member, to introduce the subcommittee ranking members.
Thank you, Mr. Chairman. On the Subcommittee on National Security, Mr. Heiss, Jody Heiss from Georgia, will be our ranking member. On the Subcommittee on Government Operations, not a new face, someone who's been very active on this committee, Mark Meadows, the gentleman from North Carolina, will be ranking member. Subcommittee on Civil Rights and Civil Liberties, freshman member. We just talked about the gentleman with experience as an assistant U.S. attorney, Chip Roy from Texas, will be our ranking member. Subcommittee on Economic and Consumer Policy, another gentleman from Texas, Mr. Cloud. There. I'm sorry, Mike. Michael Cloud will be our ranking member. And finally, on the Subcommittee on Environment, the gentleman from Kentucky, former Ag Commissioner in the great state of Kentucky, James Comer, will be our ranking member. Thank you.
Thank you very much. I want to thank all of our ranking members and our chairman, of course, for taking on the extra responsibility to do what you are about to do, and I thank you very much. Next, I want to proceed to the committee rules, but before that, let me take a moment to thank Mr. Meadows and our chairman for working with us to try to resolve any differences that we might have had or may have with regard to the rules. In particular, Mr. Meadows has bent over backwards, has consulted with me many times, and I really appreciate that. I also want to take a moment to thank both staffs. They have worked very hard. As a matter of fact, working all weekend. Staff was in the office until very late this morning. I didn't say last night, I said this morning. And I want them to know that I appreciate them. And they work tirelessly, and so often they are unseen, unnoticed, unappreciated, and unapplauded. But as you probably well know, if any of those who have been on this committee for a while, I am a staunch advocate for our staffs, both sides, because I know they give their blood, their sweat, and their tears to make our country better, and I thank God for them. Please give them a hand, please. So right now, at the very top, I would like all of us to thank our staff, which we did. I'm sure the ranking member, Jordan, agrees with me on this. I also think it's important that we make sure that no one goes after our staffs. That is an agreement I had with our previous Republican chairman. Whatever disagreements we may have at the member level, all of us, I hope, commit to keeping our staffs out of it. If there's a problem, if it should be elevated internally, it should be elevated internally. And if it can't be resolved, it should be elevated to me and the ranking member, Jordan, personally. Mr. Jordan, would you like to say anything about that?
Just that I wholeheartedly agree, Mr. Chairman. I think every member knows how hard staff works, and we appreciate that. And members should not be in any way, as I think the words you said, be going after staff members. That should be done the way you just described it, and our side agrees with that. I know we do have a concern with the subpoena language. I'd like to have a little discussion with you about that at some point here, maybe prior to our opening statements, but what you just said there, we agree with.
Mm-hmm. I also hope that your staff is enjoying their office space. Some members may not know this, but 8 years ago, when the Democrats were just heading into the minority, our chairman at that time, Mr. Issa, put our Democratic staffers up in the fourth floor in a windowless office that used to be used to hold computer servers.
We like our office space, Mr. Chairman.
Let me say this.
Mr. Chairman, if the gentleman would yield.
Of course.
I want to thank the gentleman for his willingness to work in a very respectful and cooperative way, not just with the office space, but certainly as we go into this. We all recognize that this could potentially be one of the most contentious committees on Capitol Hill, and yet your willingness to work with our staff to provide adequate workspace with windows is greatly appreciated, and I will yield back.
Well, thank you. I must say that it's the thing that hurt me, and it hurt me very badly, was that the staff was hurt. I will never forget it as long as I live. It was disheartening. And the same staff members, by the way, the same ones that were denied a decent office were the same ones that negotiated to make sure the Republicans had decent offices. I instructed the staff very clearly. I said, the same people, I said, do not be bitter. Be better. Be better. And that they did, and I thank them for that. When it was our turn, I wanted to do the opposite. I asked my staff to do the best they could, and they did. And so we did a little bit of trading with other committees, and now the Republican staff has a suite of offices right over here on the first floor with beautiful windows and views of the Capitol. And I'm glad that you are enjoying it. Now I would like to call up the resolution to adopt the committee rules pursuant to Clause 2A of House Rule Number 11. The clerk will report the resolution.
Committee on Oversight and Reform, 116th Congress, a resolution offered by Chairman Elijah E. Cummings.
Without objection, the resolution will be considered as read and open to amendment at any point. A copy of the proposed rules has been distributed to each of you in advance of today's meeting and was posted online last weekend. I will recognize myself for an opening statement, and then I will recognize the ranking member, Mr. Jordan, for his opening statement.
Mr. Chairman, any chance?
Members will be starting back up again momentarily. Okay. Let us proceed. The rules package before the committee is essentially the same as last Congress with 3 or 4 key differences. First, obviously, we have a new name. It used to be the Committee on Oversight and Government Reform, or OGR, and now it is the Committee on Oversight and Reform, or COR. This change was made in the House rules, so our rules are just conforming to that. Our committee has always examined both government and private sector issues under both Republican and Democratic chairs, and this change does nothing but reflect that reality. In addition, Rule 6 establishes 5 subcommittees instead of 6, with jurisdiction set forth in the rule. At the request of Congresswoman Norton, jurisdiction over the District of Columbia will stay at the full committee, as will the Federal Records and Public Access to Government Information. Rule 15 on the deposition authority has been changed to conform to the new House rules and the rules of committee regulation. The House returned to the practice of not requiring members to be present at depositions. Of course, members are welcome to attend, but there is no requirement for them to do so. Rule 16 sets forth the timing and the process for the chair to consider privilege assertions. This change establishes a more transparent process for witnesses to follow in order to have privilege claims evaluated by the chair and to avoid witnesses waiting to formally assert a privilege until the day a contempt vote is taken. As I explained earlier, I asked my staff to do anything they could at the outset of this Congress to start things off on a very positive note. For example, the House rules require the committee to circulate the text of these rules to members over only 24 hours before they consider them. But I wanted to go well beyond that requirement. I wanted to give the minority an ample time to review the proposed rules, to offer feedback, to resolve as many matters as possible, and to avoid unnecessary amendments here today. So we provided an advanced draft of these rules to the minority staff last Friday. And when I say last Friday, I mean my birthday on January 18th. You're welcome. Over these past 2 weeks, my staff consulted extensively with the Republican staff regarding the proposed rules. Again, I can't say it enough. I want to thank the chairman, and I want to thank Mr. Meadows for all of your staff, you and your staff's cooperation. They exchanged multiple drafts. They held multiple meetings, including our staff directors, and they were able to resolve a significant number of issues. As part of this process, we agreed to make more than a dozen changes to the rules and protocols and policies to accommodate the requests of the Republicans. For example, the minority wanted more advance notice for hearing memos, so we did that. They wanted copies of deposition subpoenas, a completely reasonable request. We did that. The minority wanted more clarification of when members can question witnesses, in which order. We made that change. They wanted us to try to post legislative text 48 hours before markups. We added that to our legislative amendment package. Now I know we are not going to agree on everything. We are not going to break from the rules of the last 8 years and reduce the authority of the chair. We are going to have differences of opinion, and I believe we know what it's like to be in the minority. But this is a good faith effort that strikes the right balance. I now yield to the distinguished gentleman from Ohio, our ranking member, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman, and happy birthday.
Thank you.
Mr. Chairman, you have considerable power. You and you alone can bring the heavy hand of government into the lives of everyday Americans with subpoenas and depositions. You have an obligation to run this committee in a manner that generates confidence in our work. Abusing our oversight authority by running partisan investigations intended to embarrass the administration should not be what this committee is about. That is not the role of this committee. 2 years ago at this very meeting, you said this: our work on this committee must not be driven by the next election, but guided by a vision of creating a more perfect union for generations yet unborn. I agree. That should be our goal. 2 years ago, you also said, talking about working in a bipartisan fashion, you used this as an example. You said, I joined the chairman in signing 740 letters to the Obama administration, state and local officials, and outside entities. 740 letters. I think that's a record, close quote. You may be right. That might be a record. In 2013, you said this to then Chairman Issa: we want your first instinct in all matters to be to consult with us and consider seriously what we have to say. First instinct in all matters to consult with us. I hope that's what happens in this committee over the next 2 years. Last month, though, you sent 51 letters to the Trump administration with no consultation with the minority. You changed the name of the committee with no consultation with the minority. You launched a security clearance investigation of the administration with no consultation with the minority. We found out about it on CNN. You sent letters to 12 pharmaceutical companies with no consultation with the minority. Michael Cohen, your first big hearing, actually your first big postponed hearing, you're going to bring a guy in front of Congress who in 5 weeks is going to prison for lying to Congress. Again, you did all that with no consultation with the minority. Now we get to the committee rules. and I do appreciate the consultation that you outlined in your opening statement that has taken place between our staffs on the committee rules. But I will tell you this, you made another change with no consultation with the minority. You got rid of the requirement that a member be present for a deposition. Now think about this. You do have big power. You can subpoena whoever you want, whenever you want, bring him in front of a congressional committee, and we're not even going to show that individual the respect of having a member present when they're deposed. So, Mr. Chairman, I do look forward to working with you, do look forward to doing the work of the people, but we need to remember, well, I should say, we need to never forget that we have a constitutional duty to do oversight, and this is the committee, the key committee where that gets done. It should be done fact by fact, step by step, and it should be done fair with the objective of getting to the truth. And I know that's your history, and I appreciate that, and that is certainly the commitment that our side has. You can win any vote we have. You got 24 members, we got 18. We understand the math. But our 18 members represent, just like yours, 750,000 people. We are here to fight for their interest, for the interest of the American people, for the truth, and we want to do it in a fair way. With that, Mr. Chairman, I yield back.
I want to thank the gentleman for his comments. Let me be real clear on this. Listen up. I said it when I was called to be the ranking member on the Benghazi committee, and I have said it over and over and over again. And maybe it just comes because I'm the son of two Pentecostal ministers. But I shall be about the business of being fair. Be clear on that. Be clear that I will seek the truth and nothing but the truth, so help me God. And I will defend the truth. I will not be about the business of wasting taxpayers' dollars, but I will get to the truth, particularly in this day and in this age. We must have it. And so I want to thank the ranking member for his comments. And now we will, are there amendments? I think we've been able to reach an agreement on the subpoena language. Okay, go ahead. Clerk? Okay.
We're doing deposition amendment first.
Are there any amendments?
Excuse me, we're going with the gentleman in North Carolina first. Mr. Meadows. That's all right, Mr. Chairman.
I yield to the gentleman.
I thank the chairman. I thank him for his opening statement and his kind words. I have an amendment at the desk that speaks to the question that the ranking member just brought up in terms of member participation in depositions.
The clerk will read the amendment.
Amendment to the rules of the Committee on Oversight and Reform offered by Mr. Meadows of North Carolina.
Without objection, the amendment is considered as read. The gentleman is recognized to explain his amendment. Thank you.
I thank the chairman, and as the ranking member was just talking about, our concern is we've had for many years, going back even to 2011, when the chairman, the now chairman, mentioned that the particular rule that we had was a good rule, one that we needed to abide by to make sure that we're efficient and effective with the taxpayers' money. And I guess, Mr. Chairman, I recognize your authority. I respect you as an individual, and I think you know that. I consider you a friend, and when you give me your word, that's enough for me. As you mentioned, I'm sure that there will be many things that we disagree on, but we don't have to be disagreeable. And so I want to thank the chairman for working with us on the body of the rules. I also would like to highlight my concern here with this particular amendment is we've got 42 members of this committee, and I have come back oftentimes. I've flown back to be part of a deposition so that we could have a member present to conduct proper oversight and depositions. And I think the vast majority of the American people believe that it should be members of Congress that dictate what this committee does, not just the staff. And that's not to minimize the staff, but if the chairman would entertain perhaps some modifications that don't go in the rules, and I know the chairman is being advised by his counsel, so I'll wait just a second. But if the chairman would consider perhaps some modifications. And so my request of the chairman is this. There are times when we're out of session in August and long periods of time where depositions that could be scheduled make it very difficult for members to be here. We're not trying to hold up the proper oversight of this committee. And if the chairman is willing to work with the members of the minority where perhaps we don't schedule depositions during the August recess, or that we have some kind of advance notice where if we want to participate, we can be there. I'm willing to work very closely with the chairman and look at how we can perhaps withdraw this amendment so that we can find a way to work together. I think the vast majority of Americans in your district and in my district, and certainly in all the members, they don't understand why members would not be at something so unbelievably important as a deposition. If we're truly doing proper oversight, why can't we find one of 42 members to be there? At the same time, I don't want to be disingenuous. I understand the logistical problems that we have in terms of trying to schedule witnesses and depositions and all that it goes. But to be efficient and effective, to use my friend's words, the chairman, I think it's important that we try to work in a bipartisan way where we look at minimizing the times where we take depositions without a member being present. And if the chairman would be willing to consider some type of modification or accommodation, I would be willing to look at withdrawing my amendment.
Mr. Chairman, would you yield to the question?
I yield.
Mr. Chairman, I'm new to the committee, and I'm just trying, my voice, trying to understand. In the previous rules, there's a requirement for a member to be here for deposition. And Mr. Meredith talks about he'd withdraw his amendment. Now, is the issue if there was ample notice given to the full committee of a deposition coming up, because you said in your opening statement you encourage members could be here if they want to be here. Is that the concern that that deposition could come up and we would not know about in time to get here if we wanted to be here, or how's the
reclaiming my time? And I think that's an excellent question. First of all, a member can be here. Any member can be at a deposition anytime they want to be here. I do not want to do anything that stops the process of us holding a deposition. In other words, if we say that a member has to be here, then I can't hold, and no member is here, that means that staff cannot go on and do their work. And I'm about to address this, by the way, and I want to answer the gentleman from North Carolina's concerns. I have said to all of our members that all of us don't have to hit the ground running. We need to hit the ground flying. We don't have a lot of time. And when you begin to look at legislative days that we're in, it's not that many, to be frank with you. And so I want to just make a brief statement. I think we can resolve this, Mr. Chairman, Mr. Ranking Member. I'm so used to I gotta get used to this.
I'll switch if you want to.
Nobody.
And Mr. Chairman, we don't want you to get too used to it.
So I do oppose this amendment. Earlier this year, the House rules removed the requirement for members to be present during depositions. Our rules merely conform to the House rules. The House decided to return to the practice that was used during the 110th Congress under Chairman Henry Waxman. To be clear, there's nothing in the rules that prevents members from attending depositions if they want to. I agree that sometimes it's good to have members present, and members are welcome to attend any deposition they would like to attend. All members will get notice of depositions and have that opportunity. But in practice, requiring members to attend just did not work and made some depositions difficult to schedule. For example, depositions could start and then be put on hold while members had to go to the floor to vote. For these reasons, I oppose this amendment and urge my colleagues to vote against it. But in answer to my colleague from North Carolina's comments, I am willing to give reasonable notification of deposition. I think, and I don't have any problem with that. I think it's important. I'd love to have members here. I just don't want the process to be held up. That's all. And I mean, and we can work that out. And I commit to that. I mean, you know, my word is my bond. And if that will help with your amendment, I'm fine. I yield to the gentleman.
I thank the gentleman. I thank him for his willingness to consider this. Let me bring up one particular time frame that's probably more problematic for members of both sides than others, and it's the August recess that we get. It is very difficult, and we call it an August recess. I don't know about you, but I don't recess when I go home and work. I mean, I can tell you it's committee, it's not committee work, but it is constituent work each and every day when we're back home in August. To have this process go on when we're going to be gone for 5 weeks makes it very problematic logistically for any member. Although on the weeks that we're off, when we're going back and forth, I don't see that as much of a deal as we look in terms of that August recess period. If the gentleman could help us specifically on that, and I yield back.
Would Chairman?
I reclaim my time. I don't want to hold up our work because the staff is working in August. But I yield to the.
Well, I would just. Mr. Chairman, our concern is this is about respect. Understand what's happening here. You are compelling an American citizen to come testify, come give a deposition in front of a committee, compelling them to be there, and you're not even going to have a member of Congress present, showing them the proper respect I think they deserve when they're called in front of a congressional committee to have a member present. It's really that fundamental, and it's been the rule of this committee for 8 years. 8 years we go. My guess is I was here. Mr. Issa did a few investigations, and we got through this. It didn't stop our work. Mr. Gowdy did a few investigations. Mr. Chafis did a few investigations. It didn't stop our work. This is about treating the American people, the taxpayers, when someone gets called in front of Congress, that's a big deal. When they're being deposed, that's a big deal. Seems to me the least we could do is have a member actually be there for that important proceeding. You yourself said you want a member present if for no other reason than to make sure the process is fair. So look, you can vote us down, I get that, and if we can work something out and you're willing to talk with Mr. Meadows and our team here and our staff, that's fine, but we can't lose sight of the fundamental fact this has been the rule for 8 years.
Thank you. Reclaiming my time.
It's something I think we should keep.
Reclaiming my time. Listen up. The very argument you just made, the very argument, you can do that. You can have your members here. You can have them here for the depositions.
And I've been there.
Wait a minute, hold on. You can have them here for the depositions. And I know that you, Mr. Meadows, and others have gone out of their way to be at the depositions. I'm not, believe me, Mr. Meadows took my words, at least he gave me a little bit of credit, about being effective and efficient.
I give you a lot of credit, Mr. Chairman.
Yeah, effective and efficient. That's all I'm trying to do. It's not, I'm not stopping members from being here. You can say that, you can make that same speech that you just made, make it to your members.
Would the chairman yield for a question?
Well, who's? Over here. Ms. Washington Schultz is recognized.
Thank you, Mr. Chairman. Mr. Chairman, isn't it true that during the August recess or any other time in which the committee conducts its work, when we would hold a deposition, the committee leadership will give members plenty of notice to be able to alter their schedules to attend a deposition, and that's what you have been communicating? So, for example, in the August recess, if you decide to have a deposition on August 10th, that members will have reasonable notice to be able to alter their schedules, and any member will be able to attend the deposition if we so choose.
Yes.
So, Mr. Chairman, doesn't that obviate the need to have a requirement? Because if the minority is deeply concerned about making sure that a member be present, then they certainly will have enough notice to be able to send a member, as would we, to make sure that there is a member present during any deposition.
Yes.
Thank you. I yield back.
Recognize Mr. Norton.
Mr. Chairman, I think we have to bear in mind all the parties involved here. There is the party to be deposed. There are how many members on the other side? 18 members. The notion that, so suppose the party to be deposed would not be available, and there was no member of the 18 who was willing to come to the deposition. That would, in effect, be veto power over the taking of that deposition. It seems inconceivable to me that if there are 18 members on that side and a person to be deposed who may be unavailable to us if the recess goes, bearing in mind the concerns of all involved, including the person to be deposed, it is inconceivable to me that every single member of your side would be so busy that they could not, any one of them, come here for that deposition. Therefore, I don't see why we should inconvenience the entire committee and perhaps lose a witness because the minority was unwilling to give us even one of their numbers during the August recess or any other time.
Would my friend yield?
Reclaiming my time. Who's
Jerry.
Gentleman from Virginia.
Thank you, Mr. Chairman, and thank you, Ms. Horton. First of all, I want to make an offer to my Republican friends. I live here, and to the best of my ability in August recess, I'm more than willing to represent them at a deposition. And I will be fair. I just want to say, I think that Mr. Meadows outlined a fair compromise here, and the chairman has taken it up, that we will give a reasonable notification prior to a deposition so that members can be allowed to attend. I heard Mr. Jordan, and I take him at his word, but I will remind him that for the last 8 years, this minority, now majority, was subjected to grossly unfair practices, trampling of rights, humiliations big and small. And Mr. Jordan used the word respect. If only that had applied. How often? We were never consulted about subpoenas. Depositions were often sprung on us. Documents weren't shared until the last minute, all designed to minimize the ability of the minority to represent the people Mr. Jordan correctly notes that all of us represent. And I salute the chairman, our new chairman, for his fair-minded way in trying to reach across the aisle and not repeat what was delivered to us. Now, there is nothing precluding Republicans or Democrats from attending a deposition if they so choose. But at heart here is the ability of this committee to undertake the oversight that's been neglected in the last 2 years. And I would commend to the chairman that, at least from this member's point of view, I welcome this rule change because it's going to allow us, even when we're not in session, to continue to the work of the committee. All depositions ultimately are subject to the review of members and the chairman and the ranking member and the members of this committee. This is, I think, a helpful change that's going to expedite the work we need to undertake. And so I support the rules change, but I do appreciate the suggestion of my friend from North Carolina and hope he, upon reflection, will accept it. I yield back.
Mr. Chairman. Mr. Chairman, first of all, I want to thank you for your openness and your fairness in this discussion. I have a question regarding what constitutes a reasonable time, and then I would like to yield some more time to Mr. Meadows.
Yeah, so we give 3 days of notice. It's 3 calendar days excluding weekends and holidays when we're not in session.
3 days excluding weekends and holidays? Yes. Excluding weekends and holidays.
So we would have 3 days' notice
Yeah.
for him. And I would like to yield time to Mr. Meadows.
Mr. Meadows.
I thank the gentleman from Georgia for yielding. I thank the gentleman from Virginia for his comments, and I think he knows that there have been a number of times when we were in the majority and I was as chair that I compelled witnesses that may not have been necessarily favorable to my narrative to answer questions on behalf of the minority,
Would my friend yield just
Sure.
for a second? I completely concur. My friend from North Carolina always conducted himself fairly and as a gentleman, and I appreciate it.
And I appreciate the gentleman, and I think we're making progress here. I would ask consideration of the chairman if they would look at a notice of 5 days instead of the 3. Just for some of us, it takes a few days to get home, and if the chairman would be willing to consider 5 days, I would be willing to withdraw my amendment in a spirit of bipartisan cooperation as we work through this.
Reclaiming my time, I just want to yield to Ms. Ocasio-Cortez.
Mr. Chairman, I actually think it's the gentleman from Georgia's time.
I'm sorry, I apologize. I thought
So,
the time was up.
And so if the gentleman would consider that, I would love to yield back to the gentleman from Georgia, and I'll let him recognize.
His time is up. His time is up, right? No. Okay, go ahead. All right.
Mr. Roy.
Mr. Chairman, I'd like to yield the remainder of my time to Mr. Roy.
Thank you, Mr. Chairman. First, I just want to thank you for opening us up in a word of prayer and recognition of the Almighty and His presence looking over this nation, and I appreciate the strong prayer from the gentlelady from Michigan, so thank you for that. Secondly, I appreciate your efforts to support and protect staff. As someone who served 7.5 years in the Senate as a staffer, sitting on these benches where these folks make this place work, I greatly appreciate that at a very personal level. And so what I'm about to say, I think takes a special importance, that I do believe that this issue is not a partisan issue. I don't believe that the amendment's importance that the gentleman from North Carolina is offering focuses on that there be a Republican member present. It's that there be a member present. I believe that it is important that a member of this body, either side of the aisle, and we respectfully would say to the gentleman from Virginia, that'd be great. That'd be super. I believe that it's important that a member that's been elected, that is holds an election certificate, be present when the power of government is being used to exercise its authority to require a deposition and force an American citizen to come before this body. So it would be my strong preference that we maintain a requirement to have a member present of either party for depositions, particularly when we're talking about the August recesses, where even with a 5-day notice, we all know the difficulty when we're scheduling things back home, particularly if you live in Texas as opposed to Virginia. And I grew up in Virginia, went to the University of Virginia, so I appreciate it very much. But I do believe that this is an important consideration that is not partisan to make sure that that is clear. Thank you, Mr. Chairman.
Mr. Chairman, in the last 10 seconds or so that I have, could we get an answer to Mr. Meadows' question about 5 days instead of 3?
I will answer that as soon as I recognize Ms. Cortez, Ocasio-Cortez. I made a commitment to her, and I will come back to her. And is that all right?
Thank you, Mr. Chairman.
All right, Ms. Cortez.
Thank you, Mr. Chairman. I just wanted to ask, once again, a clarifying question. There is nothing preventing a member from showing up to a deposition, is that correct?
That is correct.
So at any point, if we choose to show up to a deposition, we may. It's fully within our rights to do so.
That is correct.
So I think I agree in the spirit of personal responsibility and our responsibilities to here as members that we can show up to our jobs, and I don't believe we have to be forced or compelled to do so. And I also believe that 5 days, again, we are a responsive body, and I want us to communicate to the American public that we are a responsive body, that we are an efficient and effective body, and that I don't believe we need 5 days. You know, many members, I understand that many members are from different parts of the country, but very frequently we are put on 24-hour notices to show up for votes. And I believe that we can continue to be that effective and efficient body without requiring a long lead time. I know that my Republican colleagues do not like the bureaucracy and the clogging up of government going on and preventing the American public from having their services done as quickly as possible. So I just wanted to express that. Thank you.
If the gentlewoman would yield.
Gentlelady, would you yield?
Yes.
I thank the gentlewoman for yielding. Mr. Chairman, I can tell you on all of this at this particular point, we're all wanting to cooperate. Sometimes our schedules, you know, we're not just sitting around eating bonbons waiting for the call of anybody. It's truly, you know, there are complex scheduling, and that's why we all have schedulers to get this done, and I yield back. I thank the gentlewoman for
Thank you.
Pardon? Yes.
Yeah, it's your time.
For a point and then a question. I hear the gentlelady's point that there's nothing prohibiting members from getting here. My concern and reservation is that it does not reflect the operation of the way a committee will work in practice when staff moves expeditiously to move through the agenda that's given to them, to move through and schedule depositions, and that when there's not a requirement.
She reclaimed her time.
I do have a question, Mr. Chairman. In the last Congress, were things like subpoenas and other motions given ample time? Were there things like 3-day notice for subpoenas?
No.
No.
Okay, thank you.
No, because Mr. Gotti didn't issue any. 0 subpoenas. Big difference.
If Mr. Meadows is willing to withdraw his amendment, I will commit to him and to Representative Jordan, our ranking member, and all members to work with them and provide reasonable notice, including my best effort to give 5 days' notice during the August recess.
I thank the gentleman for his consideration. As he knows, I respect him as an individual and as a member representing the folks in the great state of Maryland. And with that, I withdraw my amendment, and I appreciate the gentleman's willingness to work in a bipartisan way.
I must say that I am very sensitive to this notice, and I want to thank you for your comments because I try to bend over backwards because I realize that it only takes me 40 minutes to get home driving, so I appreciate the distance that members have to come and go through, and so, but please know that I will be sensitive to all members and respect their time and try to do everything in my power to accommodate the minority.
If the chairman will yield, just for one comment.
I yield.
The difference in our districts is unique. I can tell you that same-day delivery service in my neck of the woods means that it's 3 days. And so when we look at all of this, I thank the gentleman for his consideration. I thank the way that the staffs have worked together tirelessly into the early hours of the morning, and I withdraw my amendment.
All right, thank you very much. We have reached agreement on the subpoena language. I would like to explain now, and I tend to approach the issue of consulting with the minority before issuing subpoenas. First, let me provide some history for our freshman members. For many decades, the chair of this committee has had the authority under the rules to issue unilateral subpoenas. But even though they had this power for decades, the chairs of this committee exercised it responsibly. They had a practice of consulting with the minority first, even though the rule has never required that. Unfortunately, in 1994, Congressman Dan Burton became chairman. He abandoned this historical practice. He issued more than 1,000 unilateral subpoenas during the Clinton administration. Sometimes he would issue a subpoena to the wrong person. Other times he would find out about a subpoena, we would find out about a subpoena only when we read about it in the newspapers. Needless to say, this did not reflect well on our committee. And one of the things that you will hear me say over and over and over again is that I want to make sure we maintain the integrity of our committee. Ms. Ocasio-Cortez, I see, has adopted my words again: efficient and effective. That's what we want to be about. And so when Tom Davis and Henry Waxman became chairman, a Republican and a Democrat, they believed this practice was abusive and counterproductive. They, both of them, decided to work together to return to the historical practice of consultation. And in most cases, it worked well. They both exercised this power responsibly. 8 years ago, in 2011, Congressman Issa became chairman and I the ranking member. We had a meeting just like this one at the beginning of the Congress, and I was sitting where Mr. Jordan is sitting now, and I asked Chairman Issa at that meeting to follow the same consultation process that Chairman Davis and Chairman Waxman had used. Unfortunately, Chairman Issa did not follow that process. He issued dozens and dozens of unilateral subpoenas to the Obama administration. He once issued a subpoena to the Secretary of State without even calling his office to see if he would accept it voluntarily. Chairman Gowdy, when he led the Benghazi Committee, sent armed U.S. Marshals to a witness's home to serve a subpoena on his wife without first asking him to come in voluntarily, which he would have done. It was history repeating itself all over again. So here is where we are today. Over the past 8 years, Republican chairmen have issued more than 100 unilateral subpoenas. And during that entire 8-year span, they never once agreed to any of our requests to have a debate or a vote on the subpoena. Not one single time over nearly a decade. We're better than that. We have to be better than that. I believe that we must have our own North Star. We need to put the integrity of our committee on higher ground. So here is what I intend to do. We are not going to change the rules. No substantive changes have been made to the committee's subpoena rules as they were adopted by both Republican and Democratic majorities over the past several decades. But I believe that we have reached an agreement with the ranking member on the following process. This was very carefully negotiated, so I'm going to read it directly from the text that was negotiated. And here's what it says. A congressional subpoena is a powerful and coercive tool. It should be used only when attempts to reach an accommodation with a witness have been reached at an impasse, or when necessary to obtain certain sensitive information, such as financial information, or through so-called, quote, friendly, unquote, subpoena to protect a witness. I intend to avoid the use of unilateral subpoenas whenever possible. In the normal course, I hope to work with the ranking member on proposed subpoenas well in advance. I intend to consult with the ranking member by providing his office with a physical copy of the subpoena at least 2 days before it is issued. If the 48 hours. If the ranking member objects to the issuance of a subpoena in writing, my preference is to bring the subpoena before the committee for a vote when that is feasible. Members deserve the opportunity to go on the record for some of the most important work they will do, and the public deserves the opportunity to see them do that work in the open. The chair prefers that when ranking member objects, the committee will have an open proceeding and a vote when feasible. There will be exceptions to this policy when, for example, the calendar does not permit the committee to schedule a markup between my initial consultation with the ranking member and the date on which a witness is scheduled to appear. But even in those cases, I intend to be open with the ranking member and give him every opportunity to voice his opinion on the matter. That is the text we agreed to, and that's something that the last 3 chairmen never once agreed to in the past 8 years. But here is what I am asking for return, and it is significant. I'm asking the ranking member and all of our Republican colleagues not to reflexively oppose any and every subpoena just because you want to protect the President. I know there are Republican playbooks floating around that say you and all will object to every subpoena, claim they are overbroad, and on and on. If that happens, we will revisit this policy. But I ask that you and every one of us here who swore on the oath to protect the Constitution fulfill our responsibility to protect as independent check on the executive branch. And if we all do our jobs, the committee and our nation will be all the better. I yield to the ranking member.
Thank you, Mr. Chairman. We'll view every single subpoena on its merits. That's why we want the hearing. That's why we want the vote. So I want to thank the chairman for making this this good change to the rules for, I think, the betterment of the committee and the country. We have 8 other amendments that we had planned to offer. We will withdraw those because this was the important change that we felt needed to happen for us to do the work in the appropriate and fair fashion that I spoke of earlier. And I just want to emphasize the key language in the rules change is the 48-hour notice. That is exactly what we want. And then the chair prefers that when the ranking member objects, the committee will have an open proceeding and a vote where feasible. Mr. Chairman, we like that language and are agreeable to that. And as I said, the 8 other amendments that we had planned to offer, we will withdraw, or we will not offer. And we accept this language and appreciate the chairman's work.
Well, thank you, gentlemen. Does any member have any other amendments? If no one else seeks recognition,
Mr. Chairman?
Yes.
Could I ask a question?
Yes.
Of the chairman?
Yes.
In the last 2 years, I mean, I just heard you indicate that your hope was that our friends on the other side of the aisle would put aside their Republican playbook with respect to subpoenas in the Trump administration. In the last 2 years, when we were in the minority, is my memory correct that among us on this side, led by you, 64 subpoena requests were made? Is that correct?
Reclaiming my time, yes, that is correct.
And, Mr. Chairman, did a single Republican support a single one of those 64 subpoenas?
Not to my knowledge.
So, Mr. Chairman, I will reluctantly support your compromise but I do want to register my deep reservation. Given the fact that we have a track record, it is of deep concern, at least speaking for this member, that this goodwill policy, and I think it says a lot about you as a human being and as a political leader, Mr. Chairman, that you're reaching out and you're willing to start afresh. But I am concerned that your goodwill may find itself abused, and that all it leads to is the delay of the necessary business in the issuance of subpoenas to compel testimony and documents. So I pray this works out. I pray that this reset, in fact, allows the committee to heal and to work on a bipartisan basis, but I fear otherwise. I yield back.
I want to thank reclaiming my time. Listen up. You know, I tell people, don't mistake my kindness for weakness. Don't mistake my humility for weakness. I'm about the business of being effective and efficient. I told you, I laid on my bed for 6 months. And remember what I said? I thought about my life and my death. We have a limited time to act. I promise you, Mr. Connolly, if there's an abuse, we will have to revisit. But I don't expect there to be one, because I do not want us, listen up, going to common ground. I'm trying to get us to higher ground. And I mean that. And so I got you, I understand, and I got you. I understand that, all right?
And Mr. Chairman?
Yes.
I completely respect you for that. I think you're trying to elevate and ennoble this committee after 8 long years of abuse, and I support that.
It's been 8 years. Ms. Wasserman-Schultz.
Thank you, Mr. Chairman. Just for a point of clarification on the procedures that will result when you go through the process of attempting to issue a subpoena, the chairman has retained full discretion on how to proceed and has simply added 3 days notification to allow the minority to have some meaningful opportunity for
48 hours.
48 hours, even better. 48 hours notice to the minority, but the chairman has retained full discretion and control over the issuance of subpoenas.
That is correct.
Thank you. I yield back.
Ms. Norton.
First, I want to, I suppose, compliment the chairman on his fairness, and but also to express my concern. Because when the minority was in the majority, I saw very little in the way of reciprocity of any kind. Understand what we're dealing with here. We have an administration where there has been no congressional oversight. So the first oversight is going to be by this committee. So I would ask the minority member, or perhaps I should indicate my concern. My concern about the way the minority behaved in the majority is that every single subpoena that this committee issues is going to be subject to a vote unless the minority is willing to say only under certain circumstances would we believe that, that we would oppose a subpoena. So I don't see a scenario whereby the other side, when subpoenas are issued, do not ask for a vote if that is going to be the change that the committee makes. And I yield back.
There are no further amendments.
Mr. Chairman,
yes.
if I might, I do want to thank the chairman, in light of some of these recent comments, for being willing to make this concession and firm recognition here as a freshman member of the minority that this was not the rule in the previous Congress. And I think the chairman has taken a great stride to set us off down the right path by offering this, this process that I think is an improved process. I was not here for any of the debates in previous Congresses about establishing the rules of conduct. As a freshman, however, like many of my freshman colleagues on the other side of the aisle, I bring a fresh perspective about why the American people are frustrated with both parties and how things have operated in this town. Our role in this committee, to be clear, regardless of party, in my view, is critical to the functioning of our constitutional government. We serve at the tip of the spear in defending and advancing Article I powers and exercising our review of the executive branch. It should be clear regardless of which party controls which branch. This is why I would not have agreed to the change if I'd had a vote to the change of the title of this committee. I think we should be overseeing government, and I think we should be targeted, very focused on what the executive branch is doing. That is our job in Congress, to make sure that Article I is protected. Does not matter who is in the White House. That is our job. So with that, of course we need to issue subpoenas. I'm glad that you've agreed to the change, and I just wanted as a freshman member to say that I think that is a great step forward, and I appreciate it very much.
Thank you, gentlemen. Gentlelady from California.
Thank you, Mr. Chairman. I'll be really quick. I just want to thank my fellow freshman colleagues on the other side for that acknowledgement. I'd also just really quick like to recognize that in my work previously, we worked with people experiencing homelessness who often others had given up on in terms of changing their behavior. And I'm very excited to work with you all because I believe fundamentally that behavior can always change. And this is the fresh start to a new Congress. And I believe that this is setting us off to the right tone. So thank you.
With the gentlelady yield, behavior can change for all of us, I would say.
Thank you very much. Reclaiming my time. If there are no further amendments, I move that the...
Mr. Chair?
Mr. Raskin.
Just a point of clarification. So I want to be certain about what we're voting on here. As I understand it, Mr. Chairman, and please correct me if I'm wrong, the chairman still retains the authority to issue subpoenas, but has said that within his discretion, he will try to have a vote. Is that my understanding? Is that correct?
No. That is correct.
No, this is what he said.
Wait a minute, within his discretion?
Mr. Chairman, can I
Yes.
be recognized? The chair, Mr. Chairman.
Go ahead.
The chair prefers that when the ranking member objects, the committee will have an open proceeding and a vote where feasible. Understand what we're doing here. Again, this is about respect, Mr. Raskin. If we're going to subpoena an American citizen to appear before the Oversight Committee, the key committee in the United States Congress that does oversight, what's wrong with having a discussion and a debate about that subpoena and a vote? That's a good thing. We're going to be talking about what's at stake. We're going to bring an American citizen in front of this committee. That is a good, I don't know why there's a concern. I think this should happen every single time. So I appreciate the gentleman's.
Gentleman may continue. Will you finish?
I was still talking when I heard
No.
the gavel, so
I
that's why
did
stopped,
that.
Mr. Chairman.
I did that because I was trying to make sure that people could hear you.
Okay, thank you. I appreciate that. No, I just think this is a good change to the rules, something that makes sense for everybody. Most importantly, makes sense for the person who we're going to subpoena and bring in front of this committee.
Point of order, Mr. Chairman. Point of order.
All right, Mr. Lynch.
The gentleman from Ohio just described this as a change of the rules. Are we in fact amending the rules here,
No.
or no? Okay, so I just wanted a clarification on that. Thank you.
Let me say this. I want to thank all the members for what you've said, but to the gentleman from California, Texas, I'm sorry.
Texas.
Boy, I got the wrong side of the wrong part of the country. Let me be clear. I'm so glad you said what you said, because we're going to put a microscope on the executive branch, and we need to do that. And one of the things that the American people have made clear, and there's one word that I forgot to say, I don't know how I forgot it, but let me say it now. They want accountability. The American people want accountability. They want to make sure that we are accountable, that the executive branch is accountable, and we will do that. If there are no further amendments, I move that the proposed rules be adopted as the rules of the Committee on Oversight and Reform for the 116th Congress. All those in favor say aye. Aye. Those opposed say no. The ayes have it, and the proposed rules are adopted. Now I move that pursuant to the House rules, The rules adopted by the Committee on Oversight and Reform for the 116th Congress will be published in the Congressional Record and made available to members and the public on the committee's website. Now I move that the list of subcommittee chairs, subcommittee ranking members, full committee vice chair, subcommittee assignments as set forth in the rosters be approved. All those in favor say aye. Those opposed, nay. The ayes have it, and the chairs, ranking members, vice chair are appointed, and the subcommittee rosters are approved. Without objection, the motion to reconsider is laid upon the table. This concludes the order of business for today's business meeting, and I thank you. Without objection, the committee staff is authorized to make technical and conforming changes to reflect the action of the committee in adopting the resolution embodying our rules. Without objection, the committee stands adjourned. We will now take a short break to set up for our hearing, which will take place in about 10 minutes. And we invite our witnesses to come forward.